Right, the next one is the hearings panel report to the council on brothels, location and commercial sexual services signage bylaw. Mike Davidson, Chair.
Yeah, I'll take this report as read. Been a couple of minor amendments through the hearings process to the proposed bylaw. I think it's worth saying that this consultation attracted 9 submissions. I think when this first came out in 2004, it attracted 1,500. So I guess it's a sign that that it is actually working well.
So you'd like to move it, and David would like to second it. Is there any discussion? Yanni?
Or just a question around the the multi-unit clauses, and just noting there's quite a lot of concern from NZPC around that, and I was just wondering, I'm not just quite clear if that's controlled through the district plan in terms of business, small business activity, then why we would need something in the bylaw that prohibits it. So the question really is, could that not just be addressed through the adverse environmental effects through the district plan rather than through the bylaw? Why do you need the bylaw to regulate that?
The district plan covers home occupation activities, which applies to every residential property, but it doesn't have any particular different thresholds for multi-unit residential complexes, which are apartments, townhouses and units, and there's potential for problems to arise in those multi-ownership situations where this type of business is operating from those types of properties. Just to
understand that though, couldn't you make the case that anyone operating a business in a multi-unit residential area would have a far greater impact if it was, more vehicles coming in because it was an accountant or something, or whoever else? Why do you need to single out the profession?
In this sense, because it is recognised in law as having particular different thresholds. So the Prostitution Reform Act, if a business of prostitution requires a resource consent, there is a special assessment that has to happen for any business of prostitution. So there is some recognition already through that law that it does have a high threshold or different considerations that need to be placed upon a business of prostitution.
So just so I'm clear, so basically in terms of home occupation for sex work, someone cannot do that in a multi-unit residential area even if it's just where they live and they're working from home, if we have this in the bylaw.
It's been in the bylaw for 5 years, so we're not proposing any changes to it, and there's a difference between any residential property versus this particular subset, which is the multi-unit residential complex. So that's just apartments, units and townhouses, so bits of land where there is shared ownership and common use areas and other mixes that might imply a greater potential for problems.
Right. And did you consider any sort of, or did the hearing panel consider sort of, the typology of what's happening in our city, where we are getting much more multi-unit residential being built, what the harm would be if they weren't able to work or operate from there?
What we looked at is that we have this requirement in the bylaw at the moment. We've had it for 5 years, and the view of the enforcement team is that it has been working relatively well. Most of the complaints that we have had in this area have related to the small owner-operated brothels, and a number of those have related to multi-unit residential complexes.
All right, okay, I'll put the motion. All those in favour say aye. Aye. Those opposed say no. That's carried. Thank you. Thank you. Delegations under new bylaws.